Good morning, class. Our lesson for today is about labor relation. According to Professor Joselito Gianan Chan in his outlines for 2009 pre-week bar exam on labor law, uploaded on the website of chanrobles.com, quote, labor relations refers to that part of labor law which regulates the relations between employers and workers. Example, Book 5 of the Labor Code, which deals with number 1, labor organizations, number 2, collective bargaining, number 3, grievance machinery, number 4, voluntary arbitration, number 5, conciliation and mediation, number 6, unfair labor practices, number 7, strikes, number 8, picketing, number 9, lockout. So let's move on to the brief explanation. I will give you brief explanation about these following legal terms that Professor Chan has identified. Number 1 is labor organizations. On the website of Bureau of Labor Relations, private sector, union, or labor organization refers to any union or association of employees in the private sector which exists in whole or in part for the purpose of collective bargaining or mutual aid, interest, cooperation, protection, or other lawful purposes. Number 2 is collective bargaining. In the website of laborlaw.ph, a collective bargaining agreement refers to the negotiated contract between a legitimate labor organization and the employer concerning wages, hours of work, and all other terms and conditions of employment in bargaining unit. Third is grievance machinery. Laborlaw.ph refers to a system of resolving grievances aired by employees, including but not limited to issues arising from the interpretation or implementation of the collective bargaining agreement, and those arising from the interpretation or enforcement of company personnel policies, as well as those that may be stipulated in the collective bargaining agreement or the CBA. Number 4 is voluntary arbitration. On the website of NCMB or the National Coalition and Mediation Board, refers to the mode of setting labor management disputes by which the parties select a competent, trained, and impartial person who shall decide on the merits of the case and whose decision is final, executory, and binding. Number 5 is conciliation mediation. On the website of DOLI is a mode of dispute settlement that brings together two disputing parties to negotiate and settle their differences. It is a process of rational and orderly discussion of differences between the parties to a dispute under the guidance of conciliator mediator. Number 6 is the unfair labor practices. On the website of Bureau of Labor Relations, unfair labor practices are offenses committed by the employer or labor organization which violate the constitutional right of workers and employees to self-organization. So what are some of the unfair labor practices committed by an employer? First is requiring as a condition of employment that a person or an employee shall not join a labor organization or shall withdraw from one to which he belongs. Second, contracting out services or functions being performed by union members when such will interfere with, restrain, or coerce employees in the exercise of their right to self-organization. Discrimination as regards to wages, hours of work, and other terms and conditions of employment in order to encourage or discourage membership in any labor organization. Dismissal, discharge, prejudice, or discrimination against an employee for having given or being about to give testimony under the labor code. So those are the unfair labor practices of employer or labor organization. Next one is the strikes. Laborlaw.com. Strikes means any temporary stoppage of work by any concerted action of employees as a result of an industrial or labor dispute. To strike is to withhold or to stop work by the concerted action of employees as a result of an industrial or labor dispute. A strike is the most powerful weapon of workers in their struggle with management in the course of settling their terms and conditions. About picketing, laborlaw.com. Picketing refers to the right of workers to march to and through before an establishment involved in a labor dispute, generally accompanied by the carrying and displaying of signs, placards, and banners intended to inform the public about the dispute. About lockout, again, laborlaw.com, it refers to the temporary refusal of an employer to furnish work as a result of a labor or industrial dispute. What really hurts here is when the company closes and mass retrenchments and dismissals are implemented. Moving on to the mandate of DOLE, or the Department of Labor and Employment, and other agencies related to it. The Department of Labor and Employment is the national government agency mandated to formulate policies, implement programs, and serve as the policy coordinating arm of the executive branch in the field of labor and employment. The DOLE promotes gainful employment opportunities and optimizes the development and utilization of the country's manpower resources. The following agencies are attached to the Department of Labor and Employment: Institute for Labor Studies, National Conciliation and Mediation Board, National Labor Relations Commission, National Maritime Polytechnic, National Wages and Productivity Commission, Philippine Overseas Employment Administration, or the POAA, Professional Regulation Commission, or PRC, Technical Education and Skills Development Authority, TESDA, Occupational Safety and Health Center. Let's say, for example, if you and your employer here in the Philippines do not agree on compensation and benefits. So where do you go first? Because in that situation, you need a mediator. What others do is to consult a private lawyer, maybe a relative or a family friend, or maybe the PAO, Public Attorney's Office. And then the lawyer will guide them on what to do. Others who do not know a lawyer, they go directly to the Department of Labor and Employment Office. And this is the process that will happen. I will only give a few comments according to what I know that I also learned from my lawyer friends. But it's still better to ask the lawyer for yourself when you have the chance. So this is the process. First is that you will go to SENA, or the single entry approach, and then you will fill out a form called RFA, or the request for assistance. And then you will submit that form to SIADO, the single entry approach desk officer. In SENA, they have no legal power to make a formal judgment or decision about a labor dispute. It is only for settlement, and their mandate is to settle the dispute in 30 days. And if there is no settlement happen, then an endorsement letter be issued to you by the SENA. And then that endorsement letter, you will submit that to NLRC, the National Labor Relations Commission, together with your complaint. So that is not a settlement anymore. The complaint becomes formal, and your complaint will be ruffled in the NLRC to determine who will be the labor arbiter to handle the hearing of your case. And if you lose in NLRC, there is no filing of the so-called MR, or the motion for reconsideration. But you can appeal directly to NLRC commissioners, the commissioners in NLRC, and you will do that in 10 days, in 10 calendar days. If you lose with your appeal at NLRC, then you can file a MR, the motion for reconsideration, and you will do that in 10 days again. If your MR, the motion for reconsideration, is denied, then the decision of the NLRC is final and executory. And no more appeal, whatever is the resolution that the NLRC had released. So what you can do is go to Court of Appeals, not for filing an MR, but you can file a so-called petition for certiorari, and you have 60 calendar days to do that. So that is not an appeal. The petition for certiorari is a direct accusation against the NLRC commissioners. So you are accusing them that their decision is not fair. If you lose with your petition, then you can file again, if you want, a motion for reconsideration in CA, the Court of Appeals, and you have 15 days to do that. If you lose again with your appeal, then what you can do is to go to the Supreme Court. You can file an appeal called Petition for Review on Certiorari. If you lose again with that petition, then there is no more remedy. Once you lose with your appeal in the Supreme Court, so there's no more remedy for that. Again, it is better to talk to a lawyer yourself if you experience a serious labor problem with your employer. At the moment, this is where we will conclude our study, and I hope you learned something. And you can now go to iConnect and take your quiz.